The real point of avoiding probate isn't legal theory. It's about saving money, saving time, and avoiding unnecessary complications. Every asset you own falls into one of three buckets: survivorship, beneficiary, or trust. Some assets give you options, some don't. Let's start with real estate. That's your home, the investment real estate, the woodlot, or the vacation house. You can avoid probate with joint ownership that includes rights of survivorship, or with a transfer on death deed. Some states call that a ladybird deed. Joint ownership is exactly what it sounds like. You and someone else both own the property, and if one of you dies, the other automatically owns the whole thing. But that only happens if the deed includes the right of survivorship. Not all states use the same language to create a joint right of survivorship, and not all joint ownership includes survivorship. For example, if you own property as tenants in common, that means each of you owns a piece of it, and your estate would dictate what happens to it. It wouldn't pass automatically to the other joint owner, for example. Married couples sometimes have a special form of joint ownership called tenancy by the entirety, which also protects against creditors of one of the spouses. But here's the problem with joint ownership. Are you listening? A joint owner owns your property. They, along with you, have ownership rights. If they want their share early, they can force a sale. If they get sued, their creditor can go after the property. Tenancy by the entirety helps married couples, but only married couples. Let me give you a real example. Frank wanted to make things simple. He put his son on the deed and kept a life estate because he'd heard it avoids probate and protects the house. 2 years later, Frank needed nursing home care. Medicaid valued his life estate at $200,000, far over the eligibility limit. If he gave it up, he'd be penalized for gifting. That's the gifting away that $200,000 valued life estate. That would be almost 2 years of private pay. If he didn't give up the life estate, he'd have to pay privately $15,000 a month indefinitely. Frank thought he was protecting his home. What he actually did was make it impossible to qualify for help when he needed it most. Here's another true life example. Becky added her son to her deed because she trusted him and wanted to avoid probate. Years later, her son's marriage fell apart. In the divorce, her daughter-in-law claimed an interest in Becky's house because Becky's son had paid the real estate taxes. Suddenly, Becky was dragged into a divorce she had nothing to do with. She wasn't protecting the house, she was exposing it. And here's one more. Tom added his daughter to his lake house to keep it in the family and to, you guessed it, avoid probate. Everything seemed fine, but a few years later, his daughter got sued. She lost the case, and the creditors saw she owned half of the lake house. What do you think happened? Well, they couldn't take Tom's half of the house, but they could force the whole thing to be auctioned off to pay his daughter's judgment lien. The very thing Tom was trying to protect, the lake house, was put at risk because he added a joint owner to avoid probate. Now the transfer on death deeds work differently. The person you name owns nothing during your life. They have no rights, and their creditors have no rights. You stay in control. After you die, the property transfers automatically to them without probate. It's clear and it's cleaner and safer than joint ownership. But really, these transfer on death deeds or ladybird deeds, what are they really, kind of functionally? They are a beneficiary designation, and they have the same benefits, but also the same pitfalls, as we'll see in a moment. The last method for real estate to be transferred without probate, the last method for real estate is to place it in a living trust. Think of a trust as a legal container. You put the property inside it while you're alive, and the trust continues after you're gone. Your successor trustee steps in immediately with full authority. No court, no delays, no drama. So here's the recap for real estate. 3 ways to avoid probate for your real estate is, number 1, joint ownership with rights of survivorship. Number 2, a transfer on death deed, also called a ladybird deed. Number 3, transferring it to a living trust before you die. Next, let's look at vehicles and personal property. With vehicles, cars, trucks, motorcycles, campers, some states allow transfer on death title. Some don't. So you either add a joint owner, which creates liability and creditor risk, or you place the vehicle in a living trust. With personal property, furniture, tools, jewelry, art collections, memorabilia, these don't have titles, which means they must go through probate unless assigned to a trust. A one-page assignment keeps it all out of court. What about guns? Well, guns have their own special concerns. When I say guns, I mean, a firearm. Because there are restrictions on who may own a gun, it's best to have a gun trust own it. That way, no one is accidentally guilty of a felony just for being your beneficiary. All right, that covers the more physical stuff. Now let's talk about cash and other financial instruments or accounts. Looking at the simplest, bank accounts, life insurance, and savings bonds first. For your bank accounts, the simplest way to avoid probate is to add a joint account owner. Some banks let you mark it as a convenience account, meaning the person can sign checks but doesn't inherit anything. But the more common rule is that a joint account owner inherits the entire account automatically. And joint accounts can go wrong. I once had a mother who added her daughter to her account. After she died, the daughter inherited the account, but her brothers sued her, claiming that the bank account should be determined by the last will, a will that divided the estate in 3 equal shares for the 3 children. The estate was stuck in probate litigation for years. Joint ownership avoids probate, but it can cause other problems. It can cause conflict if the estate planning isn't done right. Let's move to something simple. U.S. savings bonds. These avoid probate if they have either a co-owner, that would be like if the name on the bond said John or Mary, or a pay-on-death beneficiary. If they have neither, they go through probate unless they're owned by your living trust. The Treasury Direct website makes adding beneficiaries easy to a U.S. savings bond. Now let's talk about life insurance. Life insurance is the easiest asset to keep out of probate, but only if you have a beneficiary and a backup. If your beneficiary dies and you never update the form, the payout goes straight into probate. Same with annuities. You got to always check your beneficiary designations and keep them up to date. Now to more complex accounts, including digital assets and investment and retirement accounts. We'll start with digital assets. Digital assets are the newest and a tricky type of accounts due to those crypto locks, right? The privacy controls. Because you can't get into them without those codes. It doesn't matter who you say should get it or not get it. It doesn't even matter if you give it to your living trust. If someone doesn't have those codes, it's gone. That's it. Okay? So these don't avoid probate unless you plan ahead. But let's face it, if you don't have those passwords, you can leave it to someone in your will. You can assign it to a living trust, but it's going to be lost if you don't also preserve those passwords somewhere. Probate cannot force its way into a Coinbase account. A trust or a digital asset authorization can't protect them without the codes. You can have an orderly way for it to be passed down, but only if the codes are there somewhere. So you need to, right now, if you have one of these assets, that would be crypto or an NFP, put the instructions on how to get those crypto assets in a safe deposit box that your beneficiaries can get into after you die. What about investment accounts? Stocks, mutual funds, ETFs. These are non-retirement accounts that we're talking about. To avoid probate, you can add a joint owner, but you can also use a transfer on death designation. They're also called TOD for short. That means the custodian transfers the account to the person you name when you die. Simple. But here's the pitfall. Transfer on death and pay on death are blunt instruments. Whoever you name gets the account or the money, even if giving it to them will create problems. Here's an example. Jane inherited her mother's $300,000 stock account. Jane called and said, "My twins are about to start college. Do I have to report my inheritance from my mom?" Imagine asking the hardware store how much a screw costs, and instead of telling you the price, the clerk asks you for your tax returns. When you show him your tax returns and all your assets, he increases the price of the screw because the hardware store thinks you have too much money to pay what the screw is really worth. That's how college tuition works. Having the money means if you have an account like Jane's, you pay more in tuition, and the TOD gives that to Jane, and there's nothing she can really do to prevent it. And what if Jane had died before her mom? Her 16-year-old son, Jake, would have inherited the whole account with no restrictions. What are the chances a 16-year-old boy is going to manage that money wisely? Beneficiary designations can go sideways in so many ways you just can't imagine them all. Finally, retirement accounts. Let's talk about those. We're talking about IRAs, 401ks, 403bs, TSAs, Roth accounts. These require beneficiary designations. If you don't name one, the account can be penalized and forced into a short payout. If you name a non-person, likewise, the money can also be forced out quicker. If it is forced out quicker, that means paying more in taxes or losing tax-free growth. Name a primary and a contingent beneficiary to your retirement accounts and review them. Coordinate them with the rest of your estate plan. The lessons about loss due to a beneficiary designation gone wrong all apply to IRA beneficiary designations. Beneficiary designations as a means of planning for a valuable part of your estate can easily cause loss of assets. Think back to our pitfalls of increased college tuition, or a minor accidentally getting the money, or a beneficiary who's disabled or in a nursing home when you die. The list goes on, but you get the point. Consider the domino effect. Mark inherited his mother's $600,000 IRA. Because of the 10-year payout rule, he had to withdraw it faster than he wanted. The extra income bumped him into a higher tax bracket and increased the cost of his daughter's college tuition. And if Mark had died first, the IRA would have gone to his 18-year-old son with no guidance, no guardrails, and the kid would have the right to take the money all at once. IRA beneficiaries must be reviewed, updated, and coordinated with the rest of your estate. Otherwise, they cost families money and cause hardship. And finally, the most complex asset, a business. How do you avoid probate with your business? Business interests need special planning. Most of the people in business who I counsel own an LLC or a corporation. If you own part of an LLC, a family corporation, or a partnership, the default rule in most states is it has to go through probate. Some states allow transfer on death registration for closely held stock or even LLC interests. That means you can make a transfer on death that avoids probate for your own corporation or limited liability company. But most states don't have that yet. And even if they do, a stock transfer on death doesn't say who should run the business, or how, or for how long. But a living trust can. If your living trust owns the stock or the limited liability company interest, you can make sure there are restrictions, not just ownership. The living trust can name a manager, for instance, give detailed instructions, and keep a business running without delay. Let me give you a real example. Tony owned a pizza restaurant. He'd inherited it from his grandfather. It was known in 3 states and attracted local families and tourists alike. He ran it with the help of Marco, a loyal manager for 10 years. Tony had 3 kids under 12, and assumed his sister Linda, their aunt, would step in if anything happened. But Tony never made a trust. He never wrote down instructions, and he never gave Marco any legal authority. When Tony died, suddenly everything fell apart. Because the kids were minors, Aunt Linda was in charge. Within 2 weeks, she pushed Marco out, the one person Tony trusted. She took the money from the business, stopped paying the bills, and the restaurant spiraled. Employees quit. Inspectors showed up one by one. Everything went wrong, one thing at a time, until the restaurant had to close. A transfer on death assignment of the LLC that owned the restaurant would not have saved the business. Tony's kids didn't need ownership. They needed Tony's instructions. A trust could have done that. So let's step back. Every asset you own falls into one of these 3 buckets: survivorship, beneficiary, or trust. Some assets give you options. Some don't. But the living trust is the only tool that works for everything and keeps everything coordinated. And here's something most people never hear. Sometimes you don't actually want to avoid probate. There are 2 situations that I can think of where probate can save your family a lot of money. First, in Medicaid planning. In Medicaid planning for a surviving spouse, if the first spouse dies and the surviving spouse is already in a nursing home or enters one soon thereafter, probate might allow the family to create a supplemental needs trust. That's a special trust that allows the assets to be used for a Medicaid beneficiary without making them ineligible for their nursing home benefits. In many states, this can only be done through the probate estate. If all the assets avoid probate, the surviving spouse gets everything outright, and it counts against eligibility for that Medicaid nursing home benefit, and the family loses the chance to protect anything. Second, creditor claims. Probate allows a short window of time for a creditor to make a claim against the estate. In some states, it's as few as 4 months if you have gone through probate, but it could be 9 months or more without probate. If a creditor doesn't file in time, their claim is gone forever. Sometimes probate is the faster and cheaper way to clear debts. So even though probate is usually something we try to avoid, there are moments when choosing probate, and that's the key word, choosing, can protect an inheritance or eliminate a debt. The trick here is how to give your successors the choice. Now let me tell you about Eliza. Eliza listened to every podcast about avoiding probate. She worked hard to avoid probate. She used a joint bank account with her niece Judith and beneficiary or transfer on death for everything else. She named nieces and nephews. She went to banks, figured out the Ladybird deed all on her own. She spent hours on forms. When she finished, she thought, "Good, I'm done." Then her nephew Bobby, one of the beneficiaries, died. She had to redo everything. Every form, every institution, more calls to Vanguard, more trips to the bank, 2 weeks of work. Finally, she got it done again for the second time. Then, at Thanksgiving dinner, her nieces were talking about their brother Bobby's passing, and one of them, Judith, said something shocking. At dinner, Judith said, "I'm glad Bobby's gone. He voted for that awful political party." Judith was the niece that Eliza was relying on to take care of her one day. Eliza thought to herself, "Wait a minute, I vote for that same party that Bobby did. If Judith hated her own brother that much over politics, can I really trust her to take care of me?" So the next week, Eliza had to redo everything again for the 3rd time. The transfer on death forms, the life insurance beneficiary, the annuity designation, the deed, all of it. And that's the problem with relying solely on beneficiary designations and transfer on death tools. Every time life changes, and life always changes, you must redo every asset one by one. It's like having a dozen little estate plans instead of one central, well-organized set of instructions. a living trust. With a living trust, you only have to change one document and everything else stays aligned automatically. And a trust also handles something beneficiary forms never do. What if you become mentally incapacitated? A pay-on-death account is useless while you're alive. A trust gives instructions for care, for spending, for where you prefer to live, everything Eliza wanted from her nieces in the first place. A living trust doesn't just avoid probate, it has your voice. It's flexible enough to deal with the situation as it pans out, not as you hoped it would be when you made those designation beneficiary forms. It provides leadership, protection, and direction for the people you love. A living trust makes sure the inheritance you leave is the inheritance your family actually receives. Thanks for joining me on LifeCast, the Life Counsel podcast. If today's episode helped you see your planning a little more clearly, explore our other episodes and resources designed to help you plan wisely and live fully. Be sure to subscribe and share this with someone who might benefit.